Dying without leaving any will can make it a little bit complicated for your family to distribute your estate upon death. In South Africa, there is what we call the National Wills Week, running around September. This year it's run from the 16th up until the 20th of September. You'll be hearing this from most legal practitioners, estate administrators, the banks, the Department of Constitutional Service and Justice. They'll be calling you to come and draft your wills for free. So yes, if you have assets and you want it to be distributed to certain beneficiaries upon your death, you need to draft a will. Before I continue with this video, please note that this is not legal advice. It's important to note that my videos should not be taken as legal advice, but rather as educational purpose. Hey guys, welcome to the channel. I am Malebo, aka the Legal Guru. To those that have subscribed to my channel, thank you so much. And for those who are new to the channel, welcome, and don't leave without subscribing. So what happens when you die without leaving a will? First of all, in South Africa, when a person dies without leaving a will, they have an estate. It will be distributed in terms of the Intestate Succession Act. I'm not gonna go deeper in terms of what the act says and all that. I'm just going to elaborate on the issues of distribution, looking at practical points. Okay, so normally what you do, you normally report the estate at the master's office. Surviving beneficiaries will have to nominate an executor. Now, there's a difference between an executor and an administrator. So now in this case, let's say a person dies living without a will. They left more than 250,000 rand worth estate. The beneficiaries will have to nominate who is going to be in charge of the distribution of that estate. Now, in an event that the beneficiaries are not agreeing as to who is going to become the executor of the estate, an executor is basically someone who is going to distribute the deceased estate in accordance with the Administration of the Deceased Act, as read together with the Intestate Succession Act, if they die without leaving a will, right? So that person who has been nominated will then carry on the duties of the executor, which is distribution of the estate. There is a way in which there is a procedure in which he or she will have to carry. That's why you need to appoint someone who is well experienced in the field of estate administration to be able to distribute the estate accordingly. They will have to determine what's the amount or what's the value of the estate. They will have to determine what's the value of the liabilities, what's the value of the policies, what's the value of the claims against the estate, right? This is now the creditors, and how much will be left after paying off the creditors, the expenses, and yeah, all that, and then you distribute it accordingly to the beneficiaries. Distribution now, it can be very complex, and that's why you need someone who is experienced, because there is a way in which the Intestate Succession Act, whereby If a person dies leaving the wife and they're married in community of property, 50% will go to the wife, and then there is a portion on which it will first go to the wife and the rest will have to be distributed equally amongst the children. We have seen this in most black families, wherein not even black families, but in families wherein the estate has never been reported and the owners have died a long time ago, and maybe the grandchildren are the ones that are occupying that estate only because it's their grandparents. So in that case, it makes it very difficult for anyone to like own the property, because before you can own the property, you'd first have to report the estate first to the master's office, which would grant you the powers to now distribute it equally amongst the grandchildren that are remaining, or the remaining grandchildren, in accordance with the the administration of the Deceased Estate Act. And in that case, thereafter you'd have to appoint a conveyancer. Conveyancers will deal with the transferring of the property and everything. So you will not be able to change the names or the title deeds without having reporting that estate at the master's office. And there must be someone nominated as an executor or executrix if it's a female, to distribute that estate. And in an event that the beneficiaries are having a disagreement in terms of who should be appointed as an executor or executrix, then the master has the discretion to be appointed as an executor or executrix in that instance, meaning they will be the ones to determine who gets what and all that. Now, which is why the will is getting in here as an essential document, because it makes it easy for the beneficiaries to distribute the estate to get a share in accordance to the deceased wishes, right? So drafting a will is very important in that regard. It will show who gets what and what should be done with 1, 2, 3. Of course, you would still have to report the estate. However, the difference is here, where there is a will, there is already there's already the wishes in that will, and you already know, the executor appointed will already know how to would already know who needs to get what. There won't be a bit, obviously there are instances wherein there are conflicts and disputes in terms of what the deceased had wished for the distribution of his or her estate. Normally in that case, you will have to go to court, they'll have to challenge it and all that. I'm not gonna dwell much into that, but what I wanted to discuss was this part of the having a will. Having a will is very important in that regard, okay? But now the issue comes in when it comes to pension funds. Here, thank you, there you go. Pension funds cannot be protected by way of a will or even a nomination form. Of course, a nomination form is important to assist the trustees of the fund in making a fair and equitable distribution upon the deceased death, right? But a nomination form on its own, it's not the final say. It's not to say because you have nominated your daughter or your son for 50%, then they'll get it that way. In most instances, no, the trustees of the fund, they are given the powers to deviate from the nomination form, from the distribution in the percentages in the nomination form, and I'll tell you why. So pension funds now I'm talking about private pension funds, not the government employees pension funds, right? So the private pension funds, which is okay, I'm not gonna mention them, right? But private pension funds are, the distribution is done in terms of the Pension Funds Act of 1956. Section 37C of the Pension Funds Act grants the trustees of the fund the powers to make an equitable and fair distribution to the deceased financial dependents. Now the trick comes in there. The term dependent is defined in the act as let me just go quickly. So there's a difference between dependent and a beneficiary. Now in terms of the section 37C, we look at financial dependency. Dependent is defined in the act as a person whom the member is legally liable for maintenance. You see? Now it can either be a child, it can either be a spouse, it can either be a cousin, it doesn't matter. For as long as the deceased was financially maintaining the person, then the person qualifies as a dependent in terms of section 37C of the Pension Funds Act. Which is why you find people complaining to the PFA to say, you have allocated a portion of the deceased pension which was supposed to be allocated to me, you have allocated it to the ex-girlfriend, or you have allocated it to whosoever. The conflicts come there because most people do not understand that with pension funds, they're completely different. It's not governed by the administration of the Deceased Estate Act. That's where the tricks comes in. There is a separate regulation for that, which I've mentioned, which is the Pension Funds Act, and it's separate from the administration of the Deceased Act. So in this case, you cannot protect it by way of a will. Even if there is a will, then you can't say I want to bequeath my pensions to my children or to who. It doesn't even form part of the Deceased Estate at all. It comes as a shock to most people because most married spouses and say, because they have married to the deceased in community of property, then they are automatically entitled to 50% of the pension. No, you are only entitled to 50% of the pension during the matrimonial division, when you divide the estate in terms of the Divorce Act. But in terms of when now the deceased has passed on, unless if there is a divorce that states that you are entitled to 50% pension interest, and you can first claim that, and then which in this case you not qualify to some of the pension benefits. It's a lot, and people need to be educated, right? Need to be informed of these things. So you being married to the deceased in terms of the community of property or out of community of property doesn't matter. For as long as you cannot prove financial dependency on the deceased, then the claimant might or might not qualify to receive the deceased death benefits. You see, pension, death benefit. There's a difference between the life covers and all that, but now I'm talking in a sense of the death benefit. I know most private pension funds, they do have death benefits, and it's the same everywhere. The trustees of the fund are granted the powers to make an equitable and fair distribution. So they will identify who was financially dependent on the deceased. Those people will have to submit proofs, bank statements, maintenance court orders. It doesn't matter what the person submits, but the trustees have the final say. The board of trustees have the final say in terms of who should be allocated what percentage. And in some instances, which is rare, they can then stick to the nomination form. That is if they cannot find or they cannot locate the deceased other dependents. Now, if those dependents come later in, after 10 years or 5 years after the distribution has already been distributed, those people cannot even claim because the funds would have been distributed already. I hope I have clarified the wills and the pension funds, the difference between those two. Okay. And there are instances wherein the baby mama or the ex-girlfriend or whoever does qualify to receive the deceased death benefits. That is because that person would have been identified as the deceased dependent. And I've clarified what dependent means in terms of the Pension Funds Act. There are also funds that offer spouse pension if maybe the deceased dies before reaching the age of retirement, because I mean, if the deceased had reached the age of retirement, they would have received right their retirement lump sum or their monthly pension, right, depending on whether the person opts to receive a monthly pension or whether it's compulsory or what. It has to do with the fund rules. Each and every fund has their rules, so it's important to read those things. Okay, so yeah, when it comes to what does the fund offer in terms of which benefits does your fund offer, you have to contact them directly. They should advise in terms of what their rules are saying, and also all that sort of that. The funds have different rules. Now, some offer spouse pension. I was getting to that part wherein the person dies before reaching, the spouse dies before reaching the age of retirement and would have opted to get a monthly pension. The spouse steps in and they receive what we call a spouse pension or a widow's pension. Now, that also creates conflicts because the meaning of spouse, it can be broad. Some funds defines spouse as someone who has been legally married to the deceased. Some it's like as broad, inclusive of everyone, but the definition should be in the Pension Funds Act, and its spouse can include the customary union. The spouse can include, it's different for each and every fund as to how they differ or how they've defined the word spouse. Then you'd have to consult the specific rules of the fund to check, well, what's the definition of spouse in the rules. Mostly you'd find that people who have not registered their marriages in some funds, they would not qualify to receive the spouse pension without having registered their marriages. Some funds, they do qualify for as long as there is proof to show that the person is known to the family. It was known to the community, to the neighbors. The relationship was that of a husband and a wife. So to some funds, they would accept that as spouse, depending on what's the definition in the fund rules, and the person would be entitled to the spouse pension. So in some instances, you find that the person has been staying with their spouse, but they failed to register their marriage. Then it creates a conflict, because then some pension funds would not have recognized that as the person, the surviving spouse, as a spouse. Okay, so they would have to first register their marriage and then get the marriage certificate. Thereafter, they would qualify to receive the pension fund. And to some extent, even the girlfriends would qualify as spouse, depending also on the funds, on that specific fund's definition of spouse. They would still qualify as spouse. You'd receive most complaints about the legally married spouse complaining about their baby mamas or girlfriends qualifying as spouse in other funds. So in that case, it would go to the pension fund adjudicators. The adjudicator would have a final say whether the trustees or the board of the trustees have made an equitable distribution, or they have identified that person, or that person does in fact qualify as spouse in accordance with the fund's rules, whether the fund's rules are consistent with the definition of spouse in terms of the Pension Funds Act. So guys, it's a very broad scenario. I can go on and on and on when it comes to pension funds, the death benefits, the spouse pension. There's also divorce pension interest, which I would like to discuss in my upcoming videos. But for now, for the purposes of this video, it was in a discussion of the wills, and that the wills exclude pension. Okay, I also explained how a pension fund dealt with in terms of the Pension Funds Act, and not in terms of the administration of the deceased act. Yeah, so when you make those nomination forms, don't think that you have security, because the final say is with the board. But as I've said in the beginning of my video, this should not be taken as legal advice. Now I'm also adding, this should also not be taken as financial advice. I'm not a financial advisor, so if you need advices in terms of how you can secure your estate and all that, you'd have to approach an accredited financial advisors. These videos are strictly for educational purposes, and if you have liked my videos, please subscribe to my channel, like, and leave a comment, and don't forget to share it. For me, myself, and I, it should be bye bye.